Hello, this week we're going to learn about alternate dispute resolution. We call that ADR for short, and that acronym, you hear it so often, now you'll finally know what it means if you've heard it. And the idea is that these are alternatives to litigation. So you needed to learn about the court system first, so you'd really kind of appreciate we're talking about formality, length of time, and yes, I think that's probably the first thing that most of you think of when you think about resolving your dispute. And that's why I wanted to put this little session in here to talk to you about the fact that this is your dispute. That's important because nobody says it has to be in court. And if you are one of the parties to the dispute, especially if you're the one bringing it for a resolution, you get to choose where it is that you want your dispute to be resolved. And so this is an important session today so that you can kind of get an overview. And then as you work through the material, you will see that there are many different places you could bring your dispute. And when you choose which you're bringing it, there's some things to think about and keep in mind, and that might help guide you as to how you want to resolve your dispute. Of course, you could go the old-fashioned litigation route, and you actually may start out there. And you may start there and then move into one of these forms. You might even end up doing a combination of these other forms of ADR. So let's look at them. I like to think of the overview as a sliding scale. And if you put litigation on one end of that scale, and we're going to have the parameters of that scale be formality and expense and time, which all kind of go together, right? That would be on one end of the spectrum. And then the one that's closest to litigation of the forms of ADR that you're going to be learning about would be arbitration. Arbitration is the most common form of ADR and it is practically mainstream, especially as I teach international law. You would see in international contracts very often there's an arbitration clause, something telling you that in the event of a dispute, I say telling you, but you agree to it in your contract, that you agree in the event of a dispute arising into this contract that the parties agree it shall go into or they'd like it to go into arbitration. And if there's something like that, the courts will honor it, the judge will honor it, giving you the overview, but you'll see the details of how that is case by case. So with that in mind, arbitration is very popular, very common, and you'll see it in situations like international contracts very often because, gee, it's better than going to somebody else's country's court, right? So let's go to arbitration that we all know. There's a lot of other good features about that and how it's enforceable across different countries. So that's great for your result being actually recognized and enforced. So for those reasons, it's also very common in collective bargaining agreements. You'll see unions like the teachers union and the sports players unions will use collective bargaining agreement, which is a contract, CBA. And in that contract, there will usually be an arbitration clause, just like I described, you see in international contracts. So many different kinds of contracts have that, and plus the parties can decide they're going into arbitration. And so it's very common. And of the forms of ADR, like I said, it's more formal, expensive. You're paying the arbitrator, but still much less so and much more streamlined in time and all the rest than litigation. Now, the other thing before we slide down the scale is to say that we know with litigation, it is completely public. When you file something in court, everybody sees it if they wanted to. It's all public record. That's the beauty of our court system. It's open and transparent. But also, if you're a business or maybe an individual with privacy concerns, you might not want to put all of that, all of your dispute out there for anybody to read if they happen to want to go to the courthouse and read it, or even online where those files are. In most courts nowadays, they're all online, the clerk's office of the court. So with that, you might want to pick any of these forms of ADR because of the privacy aspect too, because those are private proceedings. You're hiring an arbitrator and the rest that we're going down that path, you'll see that this is something that differs from litigation in that respect as well, which might be a desirable thing for you. Okay, so we're going to look at arbitration, mediation, and in mediation, it's not a third party who's deciding the case. There's still a third party, like an arbitrator. In the case of arbitration, that person's deciding the case much like a judge. And in a mediation, there's a mediator who's also a third party, but that person is facilitating. and helping the two other parties, those of you in the dispute, come to this decision of what you're going to do to resolve your dispute. So it's a different role for the third party. As a result, it's a little less formal. There aren't the same kind of rules and decision making because there isn't a decision being made, right? And it's sliding down the scale of less money and more casual, right? Less formal as it's going. Okay. And then we're going to look at combinations of those. You can have ARB Med or Med ARB, where you start out in one and go to the other, or vice versa. You'll see that. You'll see things like mini trial and mock trial. And the difference there, a mini trial, it's the executives of the company who are going to make the decision ultimately and almost settle the case. But instead of just getting together in a room, here they have sent it out to their legal teams. It's become a legal dispute. And a mini trial turns it back into a business dispute by having those lawyers play the case out like a trial, right? And you'd see both sides because it's there out in the open. You're seeing both sides, and you are the company executives, the ones who are the decision makers in that company. And very often, and there's great statistics about it. In fact, I've seen one, and it's probably gone higher since then, but that 85% of mini trials are successful, which means that the business people come to a resolution together, repair the relationship before it's gotten so adversarial as you've seen with litigation. And then we have mock trial along the same kind of lines, but in there, the jury is a random groups of folks. And I say groups because often you can go to a dispute resolution center, an ADR center, some of them are called, they have different names, and you can have them put together a group of people that will be your mock jury. And you know the word mock, you know it means it's not a real jury. This is not a trial that's held by the court system with a binding result. Instead, it's going to be a group of people that are sort of witnessing the attorneys play the case out. It's not just for practice or playing, it's also to see the strengths and weaknesses of your case and poll this mock jury, ask them how they would have decided and what were the factors that helps you. But also, you're both doing it, both sides, and you see each other's strengths and weaknesses, and that often leads to a settlement. So that's another nice feature of a mock trial. And then we get to all the way down into the area of negotiation or just settlement. And of course, you can settle your case anytime. And even if you're in the court system litigation, the judges very often have settlement conferences. I know my judge used to do that and really encourage the parties to settle their case and not take it the full 9 yards down to the jury. Well, in a mock trial, it's that mock jury. In a mini trial, it's your executives. And in a ordinary negotiated settlement, there is no third party there or even another group like a mock jury, and you get to decide your case yourself together. And so there's some nice techniques of negotiation to help you do that you'll read about in the book as well. So that's our overview of where you're going with ADR. Think outside the box, be creative, see where it takes you, and remember it's your dispute to resolve. So you can resolve it any way that you'd like, but when you choose one of these paths, often it's an alternative to litigation, which means you can't come back to the court afterwards and have a second try. And some of them, if it's the word binding in front, pay attention. Binding arbitration, that means that the result is final. There is no appeal like there was in the court system. And if you come to court and you ask them to overturn the arbitrator award, beware, because it's only very limited. In an arbitration, it's binding, so they can only overturn it if there is fraud, corruption, or it's against public policy. And so you can't just say that he made a mistake, Your Honor, or they didn't take into account these factors. It would have to be saying some kind of corruption went on and that the process was corrupt, not that the merits were wrong. So be careful with that. If you have an arbitration clause in your contract, like I described at the beginning of this video, that's considered voluntary arbitration, binding arbitration. So you've already chosen your path even before your dispute has arisen. You've already agreed to it in your contract. Now, don't ever say, you'll hear me say this many times in this class, don't ever say, well, I didn't read the contract. I didn't see that in there. Well, you could say it, but it'll have no effect because we're going to, and you'll see this when we do contracts in here, we are going to take it seriously that that's a contract that you agree to all its terms. And we want you to be wise folks who do read your contract, just like we want you to be those who are not ignorant of the law. And that's really why we're going to really have you throughout in society be held responsible for what you've agreed to. And we're going to honor it and say, well, you agreed to this, so we, the courts, are not going to overturn it. We are going to support the decision that you made to go into this alternate forum, to go into arbitration instead of going through the litigation system. So that's our kind of our picture, our mindset as you go in. And hope you enjoy learning more about ADR and seeing that there's all different ways to resolve your dispute.